The Gauteng Division of the High Court in Pretoria has declared certain provisions in the criminal law, that's the Sexual Offences and Related Matters Act, to be unconstitutional and invalid, as they do not criminalise sexual violence where the perpetrator wrongly and unreasonably believes that the complainant was consenting to the sexual act. Joining us to discuss the judgment is South African human rights lawyer, Anti-GBVF activist and co-founder of The EmbraceProject, Germanos Manuel. Good evening, Lan. Thank you very much for joining us on the program. Now, as the EmbraceProject, you've come a long way with this case. You brought the challenge back in 2022. It was heard this year in July. We spoke, you and I, in fact, and now you have your judgment. Your reaction?
We are elated beyond belief, especially because we didn't anticipate, or I personally didn't anticipate the judgment to come out this soon, and for it to be just such a clear victory. The judge really gave us everything that we actually asked for in terms of our relief. So we couldn't be happier. This is a true victory for all GBVF victims.
Now, for the benefit of those who might not have followed this specific case, I want you to take us back to the issue of intent in the Criminal Law Act, because it's what you found quite problematic, among others, where beyond proving non-consensual penetration, a victim has also had to prove that the perpetrator intended to rape him or her. Unpack this aspect that you found quite worrying.
That's actually such a beautiful framing of what the exact issue was. So, I mean, the state proved that there was failure consent on the part of the complainant, and that there was a penetration, but where they would fail or fall short is being able to have reasonable doubt that the accused had intended to commit rape in this instance.
And which would be difficult to prove, because then you'd have to get into the psyche of that perpetrator to know that this was the intention or not the intention.
Absolutely, and that was what created the biggest barrier for the prosecution, because we were now, what the court was asking was, you know, what is happening in the state of mind of the accused? And the threshold the court was using was, well, you know, is the accused's version reasonably possibly true? And I mean, that is a super low threshold. And that's exactly what the court now has overturned. It said that, you know, that cannot be the threshold for proving criminal intent when it comes to sexual offences. And instead, that has now been replaced by an objective test. So the question that the court is now going to be asking is, would a reasonable person in the position of the accused have come to the same conclusion? In other words, would a reasonable person in that circumstance have believed that consent was given? But what the court has also done is it's gone a step further. It's given us what we've asked for in terms of an interim reading, because when you declare sections in an act unconstitutional, you can't leave a loophole in the law. Or rather, you can't leave the law bare, because unconstitutional means you can't use those provisions.
But there must be something to use in the interim.
Absolutely. And what we have asked for, the reading in, is that there now be a positive obligation placed on an accused person to take objectively reasonable steps to ascertain consent. So for the first time ever, the law is requiring that an accused person takes positive steps to ensure that they have consent, as opposed to assuming that they have consent due to a victim's silence or failure to resist.
So if we had to be granular or practical, what could that possibly look like if one is now to get that consent from a partner, perhaps?
So, I mean, the law has actually left it like quite open. It's not a closed list. That's why the law uses words like objectively and reasonable, so as not to dictate to people, you know, the exact steps you have to follow in order to make sure that you've ascertained consent. So that could be anything from, are you okay with this? Do you want me to stop? It could probably even be a gesture, you know, like a thumbs up, and then wait for a thumbs up back. You know, the law is not going to be prescriptive on that, and it'll be decided on a case-by-case basis.
Because there was a bit of a debate among others that is it now going to come down to where individuals, before they are to engage in any sexual conduct, they would have to either write something down where the person says, yes, I do consent to us actually taking the next step?
No, it doesn't have to be as formal as that at all. I think something that we all need to remember is when it comes to sexual offences, this is usually a crime that's committed as between two people. And it always comes down to one person's word against another. And the court, as it has always done, will decide on whose version is more credible, who is the more credible witness. So if an accused person comes forward and says, I did take reasonable steps to ascertain consent, this is what I did, this was the response that I got, and if the court finds that their version is plausible or the most credible, they're going to acquit the person. In fact, for those who are concerned about, false accusations of rape, this added requirement, if you follow it, it would actually sort of ensure that you would get acquitted in the case of a false accusation, because now you've taken definitive steps to confirm that you obtained consent.
Okay, so the reasonable man test will apply here. But now, Leanne, you pursued this matter on behalf of thousands and thousands of GBV victims. And now this matter has come full circle. How do some of the victims that you have interacted with, represented, fought for, how do they feel about this judgment?
Honestly, I think my elation comes from their reactions. And as I hear more and more from friends or colleagues who have been touched by these heinous crimes and where they have also been failed by the criminal justice system for the very reasons that we went to court, seeing their emotions, hearing what they have to say is really what has made this journey so worthwhile. And I would do it again and again and again just to get one of those reactions. Those victims know that in their cases, this amended law will not apply to them because the law can't apply retrospectively when it comes to criminal law. But in each one of their cases, they have expressed their elation at the fact that going forward, other victims will not have to go through what they went through and that they still feel vindicated. And I think that's probably best shown by the second applicant, Inge Holstracher, who's now also quite happy to be identified. She has come forward and expressed her elation. And I mean, this is a journey for her personally. Her rape matter will never be retried. But she put herself through the criminal or the court process once again when it had failed her previously, all to ensure that nobody goes through what she goes through again. And she's come out victorious.
What a noble and just cause that you have fought, Leanne. Thank you very much for joining us this evening. That's Leanne Germanos Manuel, South African human rights lawyer and anti-GBV activist, as well as co-founder of the EmbraceProject.